Welcome to Atlanta Estate Planning with Terry McGinn.
Well, hi, everybody. My name's Terry McGinn. I appreciate you tuning in for this podcast. I'm an attorney in the Atlanta area. I practice estate planning law, and I also do probate litigation whenever the need arises. What I want to talk about today in this podcast is wills, just general will provisions and information, and we'll go through some of the many questions I normally get from my clients. So it's to be noted that with or without a will, under most circumstances, heirs will be required to sign an authorization to allow the executor or administrator of the estate to be appointed. So let me give some definitions here. So what is an heir? An heir is a blood relative under Georgia statutes and most other state statutes who are legally entitled to the assets of the estate if there is no will. If there is a will, the assets of the estate are to be given to the beneficiaries who are listed in the will. So an heir can be a beneficiary can be an heir, but the decision whether or not an heir is going to be able to receive any of the assets of the estate basically depends upon whether there's a valid will written or not. However, under Georgia law, irrespective of whether there's a will or not, and if there is a will, the estate is called a testate estate. If there's no will, the estate is called an intestate estate. So intestate, no will; testated estate, there is a will. Whether or not there's a will or not, the law in Georgia, and I think other states adhere to this as well, all the heirs of the deceased need to sign an acknowledgment that they agree with the appointment of the executor of the estate, and the executor is the person named in the will who's going to handle the assets after the testator or the person that writes the will becomes deceased. A lot of people are surprised about that. For example, let's say that I'm listed as a child of the person that died, but I'm not listed in the will. It's very common that somebody is not listed in the will as a beneficiary, but I'm a relative. And so I can make a claim against that, but I might be an heir, but I'm not a beneficiary. However, under the law, in Georgia at least, an heir must sign an acknowledgement that I, as an heir, agree to let the executor, whoever has been appointed in the will to administer the estate in a testate estate, or whoever the administrator is. An administrator is equal to, legally, an executor, but there's no will. So it's an intestate estate. A petition is filed stating we want Terry to be the administrator of the estate, and we are all the heirs, and we agree to that. So that is a peculiar situation where I, as an heir, might not be directly benefiting from any of the assets of the estate, but in order to make sure an intestate estate is smooth, the court, under Georgia law, the court requires that all the heirs agree to the administration of the estate because there wasn't a will. Sometimes that's a difficulty doing, and it's one of the thorniest issues I come into when I'm probating an estate. So if not of all the heirs agree, there is a procedure where a hearing can be held, and I go into court and I explain the reason why, and we've done our due diligence and notified all the heirs, and they still refuse. Then the administration of the estate can't proceed. Those people are not going to receive any money or any assets typically in that event. So a lot of it depends upon how the heirs determine whether or not they're going to object to the probate of the estate. If they object, it turns into a legal case that lasts maybe 6 months, or typically longer than 6 months, maybe a year or so. So that's expensive and that's costly. So let's talk at this point about who is an heir and the rules of inheritance. Again, this is if there is no will. But under Georgia law, whether there's a will or not, and I'm reiterating, heirs have a say in whether or not the administration of an intestate estate or an estate with a will goes smoothly. So how do we determine who is an heir in an estate? So if the deceased is survived by a spouse and no children, the spouse is the primary heir. If the deceased is survived by a spouse and children, the spouse is an heir and the children are heirs. Again, there's no designation as to for a will here. So the wife or the husband is an heir and all the children of the deceased are heirs. There's a crimp on how much the children in this particular situation are going to receive. The law in Georgia is the minimum amount a spouse can receive where there are children of the deceased is 1/3 of the estate. So if the deceased had 5 children, the 5 children are going to have to be satisfied with 2/3 of the estate divided into 5 parts, which diminishes each. It's also important to note that in a blended family, the spouse who survives the deceased, if their children outside of the marriage, maybe the deceased was married before, and these children were not adopted by the surviving spouse, they are still heirs, and they still count in the designation to receive whatever the estate is in the administration of the estate. So that's the case. 1/3, minimum of 1/3 to the spouse, and then the remaining 2/3 to the deceased children, be they children from the current marriage or not. What if there's no spouse? Well, children of the deceased are considered first-degree heirs, which means that if there's no spouse, the spouse predeceased the decedent, and there's 3 children, they are all considered first-degree heirs, and typically they would be divided equally among the 3 children. Let's take the situation if in this case there is no spouse, there are children, but one of the children has predeceased the deceased, but that child has children. So hypothetically, I'm not married, I have 3 children. When I pass away, before I passed away, one of my children, God forbid, has predeceased me, and that child has 2 children, my grandchildren. So the 2 grandchildren would stand to inherit by means of administration of an intestate estate, 1/6 of the estate for each of the children. Normally, it would be a equitable division between, in my hypothetical, 3 children. One of them has predeceased, but he has 2 children. Each of the 2 children would receive that deceased child's share on an equal basis. So each would get 1/3. The other 2 children would get, each of the 2 children, essentially my grandchildren, would each get 1/6, and the 2 surviving children would each get the remaining 2/3, 1/3 each. So they are considered first degree, first in line to receive if there's no spouse. If I die, I'm not married, and I have no children, the parents, if my parents are still alive, are considered second-degree heirs. They're next in line. If I die, so they're called second degrees. If I die, I'm not married. I know I'm being repetitious, but if I die, I'm not married, I have no children, and my parents are all deceased, and this happens on a regular basis. Any brothers or sisters I have are in the third degree of inheritance. So they're third degree heirs. Now, the question arises, what happens if my parent who's deceased, I have half brothers and sisters? Georgia does not recognize half siblings. They're either, if they were descended from the deceased, but they were not adopted by the deceased, by the spouse, they are still considered full first degree heirs. So if I have step siblings, they're to be considered full siblings as full heirs in comparison to me. So my dad might have died and I had a different mother, but my dad had a previous wedding or marriage and he had several other children who are not full-blooded siblings of mine. They, under Georgia law, would be considered full siblings of mine, or full children of my hypothetical deceased dad, and they're going to share equally with me whether or not my father, whether they were adopted or not. So that's kind of what that is. That's the third degree, or else siblings. What's the next degree of inheritance, step by step, going farther and farther away? Grandparents, if they're alive, are fourth degree. So again, I wasn't married. I have no children. I have no brothers and sisters. My grandparents, my one grandparent is still alive. He or she is considered the primary heir, and that grandparent is going to be receive the estate. In the event that all that happens and I die, my grandparents are not alive, my parents are not alive, I have no children, no wife, then my uncles and aunts are fifth degree. And alternatively, my cousins. So just as if, and so if in that hypothetical example, one of my aunts has predeceased me, and I've just got two uncles left, my cousins from my aunt who's predeceased me would take the position of whatever their portion that their parent would have received. So just as the same example, if I had two uncles and one aunt, and my aunt had two children, and she predeceased me, and so my uncles, each uncle would receive 1/3 of the estate. My aunt, since she's gone, would not receive it, but her two children, my two cousins, each would receive 1/6 of the estate. So that's the degrees up through the fifth degree of how Georgia law decides if there's no will and there's no beneficiaries, who would have the ability to inherit the estate. More remote than that is kind of a complicated scenario. What happens is you figure out who the common ancestor is to my cousin's children, and you count backwards and up. So you can have fifth, sixth, seventh, eighth degree heirs. Everything would be accounted. You just need to go through a step-by-step procedure. I don't want to overcomplicate that now. But so heirs are determined by what degree they are in relation to the deceased. Now, what happens if a child dies, but it's been abandoned by its parent? Under most circumstances, that child, the estate from that child, that parent that abandoned the child, would not have any recourse to claim that child because they were the parent. What about out-of-wedlock children? Out-of-wedlock children may inherit as children born in wedlock from the mother or the father. So if the child was born out of wedlock prior to the marriage of the deceased to another spouse, and they in that marriage produced kids, the out-of-wedlock child, the premarital child, as I like to call them, would be on equal standing with the children who are legitimated or legitimate children of the deceased. There are certain rules that I won't get into, but unless the child who is premarital has been legitimated by a parent, that would, by another person, that would disqualify a premarital child from inheriting any of the estate. So those are kind of little complex situations. I don't see it all the time, but if the child's been, a premarital child has been legitimated by another party or adopted by another party, then they will not be able to qualify as a child in the estate, because legally somebody else has stepped up and say, I am Terry's parent now under the law. And that typically would cut them off from inheriting anything of the biologic father or mother's estate. So what about filing a petition for inheritance, be it an intestate position where there's no will, or a petition where there is a will, or there is no will intestate, there is a will testate. It's normally the same procedure. A petition is filed in probate court in the county of the deceased, where the assets of the deceased are located. Say somebody dies in my county, Cobb County. They had a house in Cobb County. The estate, the probate estate, would be established in Cobb County Probate Court. Another example of a wiggle on that. Let's say that somebody dies in Cobb County. They have a real estate in Cobb County. They have all their assets in Cobb County. That's where they live. That's where they became deceased. However, they have a country house in South Carolina on the lake. Well, in order for that asset that's not into the jurisdiction of Georgia to be admitted into probate in Cobb County, what would the attorney or whoever's administering the estate would need to file what's called an ancillary petition. It's a second petition that's filed in the other state where the assets are located. So that's an issue. You got to go through a separate procedure. An attorney can assist you with that. I normally do ancillary petitions probably 5 or 10 times a year. It's fairly common. What about if a person dies in Georgia, but they are out of state? Then the same thing. There's going to need to be some administrative work. We're going to need to verify the witnesses, etc. And so that's where that is. So when kinship or legal relationship of any parties in controversy, a court may order DNA testing from the remains of the decedent if DNA is not otherwise ascertainable, and a party for determination. So in brief, this happens a couple of times a year. I get a call from a party that says, I am my father's daughter, but he never legitimated me, never signed the birth certificate, he never signed an affidavit, there was no court order. How can I claim my part of the inheritance in the estate? Because I was, but I've got some evidence that he recognized me. The main reason is the court's going to have to order DNA testing. That person's going to have to surrender DNA. And if there's DNA record from the deceased, that is what's going to be used to compare. And that's by a court order. So these are just some of the more nuanced approaches of things that happen in administration. The main thing I want to reemphasize is, number one, whether you have a will or not, if there's assets that are not listed in a trust account, which are outside of probate, we talked about that in a previous podcast, a probate court will need to determine whether or not the will's valid, and if so, then the property is going to be designated to the parties, the beneficiaries in the will, or whether or not there's no will, whether or not the heirs are going to be declared as heirs, and how that estate's going to be distributed. So that's about all the time I've got for right now. I really appreciate you guys tuning in. So please go and go to my website. My website is lawga.com, lawga.com. Put a question through, and I'll do my very best to answer all your questions. Thanks so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.